Ask our cameras to please leave. Thank you. Well, good morning, colleagues, and welcome to our witnesses here today to meeting number 54 of the Standing Committee on Public Safety and National Security. And today we're going to continue our study on Bill C-51, an act to enact the Security of Canada Information Sharing Act and the Secure Air Travel Act, to amend the Criminal Code, the Canadian Security Intelligence Service Act, and the Immigration and Refugee Protection Act, and to make the related and consequential amendments to other acts. Of course, we have a group of witnesses today here now, and for the first hour, we have further witnesses for the second hour, and then of course we have another tablet of witnesses for this evening. So we will start, of course, with opening statements from our witnesses here today, and we would remind you that you're entitled to a max of 10 minutes, but of course, should you be able to be a bit more brief, that would give more and more opportunity for the committee to have a dialogue with you. So at this particular point, then, we will welcome Carmen Chung, the Senior Counsel from the British Columbia Civil Liberties Association. From Greenpeace Canada, we have Joanna Kerr, the Executive Director. We also have Keith Stewart, the head of the Energy Campaign. And we have, as an individual, Ron Atke, the professor from Osgoode Hall Law School, York University. So welcome to all of our witnesses today. And so we'll start off with opening statements now. And Ms. Chung, you have the floor.
Thank you, Chair.
Oh, point of order. Mr. Easter.
Mr. Chair, I'm not exactly sure the procedure here, but the Minister of Justice at the last committee meeting when he appeared said some not too pleasant things about the British Oversight Committee. And quite honestly, the Minister of Justice was talking about history and not to date. I have before me here a report that was tabled in the British Parliament by their Intelligence and Security Committee of Parliament, which explains what they do. It shows how fast they act. The problem is, Mr. Chair, it's 200 pages long. And it goes through, yes, the concerns that they originally had and how they upgraded that Intelligence Committee in 2000 and by the Justice and Security Act 2013. I think it would be important for committee members to have a copy of this committee. It does show the good work they do. It basically refutes what the Minister of Justice said in terms of how they do it. But it's not bilingual, and I would like to table it before the committee, or at least the summary of that. I can get the summary translated if that was the way we want it to go. But I understand the need for it to be bilingual. So I guess I'm at your disposal, Mr. Chair. How do I get this tabled so that the committee has access to it? Because it is pertinent, and it basically refutes the misinformation that the Minister of Justice gave to this committee, how their oversight committee operates.
Okay, well, thank you, Mr. Easter. Two thoughts on the matter. Of course, under our routine orders, anything that wished to be tabled before the committee must be in the duality of languages, unless, of course, we have unanimous consent to approve a tabling of any document in any form in the present form that it's at. Yes, Mr. Ray.
Might it be possible for the committee to translate the documents that will be tabled? Or ask? A summary, in fact? In both official languages?
If that is the will of the committee, if Mr. Easter wished to prepare a summary and or present a summary in the both official languages, it would be pertinent to discussions that have already taken place, and it would be allowable at that point.
Thank you, Mr. Chair, and thank Roseanne. I will do that.
Okay, thank you very much. Yes, Ms. James.
It's my understanding that for something to be tabled in this committee, it has to be presented or tabled in both official languages. Any time in the past that this issue has come up, the opposition has demanded that it be presented in both official languages before it's tabled. And I think that we should stick to the rules that govern this committee. That has been in the past as well. I have no problems with the the Liberal member opposite, having that translated for the committee and then tabling it at that point.
That is what the chair has suggested.
Okay, thank you.
The chair has suggested that it had to be translated, the summary, in both official languages if he wished to present just the summary. So Mr. Easter certainly can look after that, and should he not, of course, then we would rule otherwise. So we will now go back to our opening statement. Thank you for your patience. Ms. Chung, please carry on.
Thank you, Chair. Good morning. It is a privilege to appear before the committee again. On behalf of the British Columbia Civil Liberties Association, I'd like to thank you all for your invitation to speak today. The BCCLA is a nonprofit, nonpartisan organization based in Vancouver, British Columbia. For over 50 years, the mandate of the BCCLA has been to promote, defend, sustain, and extend civil liberties and human rights in Canada. We have submitted for the committee's consideration a written brief setting out our chief concerns with Bill C-51 and hope that as the committee examines this bill, it will consider not only whether its provisions are constitutionally compliant, but whether they are also efficacious and just. We raised 6 chief concerns in our bill. Given our limited time here, I can only canvass them in my opening remarks, but I do hope that the committee will refer to our written submissions, which set out our views in greater detail. First, it is our submission that the Security of Canada Information Sharing Act is fundamentally flawed and should not be enacted. It endorses a radical conception of security unprecedented in Canadian law and an unbounded scope of what it means to undermine Canadian security. Based on these expansive concepts, the Act authorizes warrantless information sharing across government and dissemination outside of government. As the Privacy Commissioner has pointed out in his letter to this committee, such widespread and relatively unfettered access to personal information poses serious dangers for individual privacy. We and others have also suggested that such massive data collection and information sharing may not necessarily benefit security either. Moreover, the Act deepens an already serious deficit in national security accountability. Professors Kent Roach and Craig Forsees have extensively detailed the legal problems with this proposed Act, and so we will not repeat them here. Paul Champ, who is appearing on behalf of the International Civil Liberties Monitoring Group later today, will discuss in greater detail the human rights concerns raised by the Information Sharing Act. We share the ICLMG's concerns. We add only the following observation. To those who might say that this proposed act poses little threat to freedom of expression and dissent, recent examples show that government already takes a very wide view as to what constitutes a threat to Canada's security. We need only to look at CSIS and RCMP monitoring of nonviolent protests undertaken by First Nations and environmental groups. Second, it is our submission that the Secure Air Travel Act should be rejected. As a threshold matter, we question the efficacy of no-fly schemes in general. Travelers on such lists are deemed too dangerous to fly, yet too harmless to arrest. It is our view that if law enforcement officials have enough information to determine that an individual poses a threat to aviation security, or that they are planning to board a plane in order to commit a terrorism offense, they are also likely to have enough information to lay charges or to seek a recognizance order with conditions. If it is indeed necessary to impose a travel ban, then the criminal law is already well equipped to allow the government to seek a court order to that effect. But even if no-fly schemes do improve aviation security, the system proposed here suffers from serious procedural deficiencies. The proposed act creates a system where travelers have no concrete way of knowing whether they are on the no-fly list, where the reasons for listings are largely kept secret, where the judicial process for reviewing delisting applications can be held in secret. This is a dangerous lack of due process. And while travelers can't access information relating to their own listing, the proposed act does allow the government to share its no-fly list with other countries, with no statutory limitations on how that information can be used by a foreign state. Canada's experience with mistakenly labeling individuals as security threats and providing that information to foreign governments should counsel against such carte blanche approaches to foreign information sharing. Third, we oppose the creation of an advocating or promoting terrorism offense in the criminal code. We see no security interest in further criminalizing expression beyond what is already prescribed by law. The criminal code already makes it illegal to counsel anyone to commit a terrorism offense. Considering that terrorism offenses include acts that fall well short of violence, such as preparing to commit terrorist acts or supporting terrorist activity, this already captures a broad range of terrorism-related expression. Similarly, the participating, facilitating, instructing, and harboring provisions contemplate recruitment and instruction to commit terrorist acts as criminal offenses already. In Kawaja, the Supreme Court of Canada also considered the constitutionality of the definition of terrorist activity in the criminal code and allowed it to include threats of violence. This new offense, then, would criminalize expression far removed from acts of terror or violence. It would make criminals of individuals whose sentiments may never even leave the confines of their own living room, as so long as their listener is someone who might commit a terrorism offense. The new offense contains no requirement that the speaker actually intend a terrorism offense to be committed, and it also contains no requirement that the listener commit a terrorism offense either. Endorsing acts of terror may be upsetting to some and repulsive to many, but freedom of expression is what creates a democratic society in which we can debate the merits of ideas, even those that as individuals we find deeply offensive. A democracy is based on the premise that individual citizens have the capacity to govern themselves, to understand and to evaluate different perspectives with which they are confronted, to deliberate their merits, and to ultimately decide which viewpoints to adopt and which to discard. Accordingly, we urge this committee to reject the creation of this new offense. Fourth, we submit that this committee should reject the proposed preventative detention amendments. Bill C-51 expands a troubling regime of preventative detention by lowering already low thresholds for detaining individuals on mere suspicion of dangerousness. When this committee debated the reintroduction of the preventative detention provisions currently in the criminal code, we expressed serious concerns about the necessity for such sweeping arrest and detention powers. While we continue to believe that it is preferable to charge terrorism suspects under the criminal law so that they are afforded appropriate due process protections, the fact remains that the government already has extraordinary powers at its disposal. The question that this committee and that all Canadians should be asking is not what additional powers that should be granted to government to protect public safety, but how well existing powers are being used and whether the existing criminal law is being properly enforced. Fifth, we believe that the proposed amendments to the CSIS Act are unwise and unnecessary and should be rejected. By giving CSIS the power to engage in threat disruption, Bill C-51 blurs the line between spying and policing carefully drawn following the McDonald Commission. This threat reduction power is a policing power. It is a policing power made extraordinarily broad by virtue of the expansive definition of threats to the security of Canada contained in Section 2 of the CSIS Act, a definition that was constructed to set out the mandate of an agency responsible for collecting and evaluating information, not a policing authority. It is a policing power made dangerous given the secrecy that accompanies national security activities. Rights violations may be more difficult to detect, and once detected, more difficult to remedy. And it is a power that seems wholly unnecessary. Government has provided little evidence for why this expanded power should be granted to CSIS, or why CSIS should have any policing powers at all. We are deeply troubled by the proposed CSIS warrant powers in this bill, and the proposition that Canada's courts should be tasked with authorizing measures that violate constitutional rights. As many others have observed, this profoundly misconstrues the role of the court in our constitutional system. And to ask the court to authorize violations of fundamental rights, such as those protected in the Charter, is simply offensive to the rule of law. Over the past decade, we have seen the effects of an approach to national security that privileges bare legality and at worst descends into illegality. The consequences for the rule of law and human rights have been profound. Meanwhile, it remains an open question whether the gloves-off approach to national security has made Canada or any of our allies any safer. Finally, Bill C-51 ignores the Supreme Court of Canada's teachings that the government cannot rely on secret evidence in security certificate proceedings without providing some way for the named person to know the case to be met and a procedure by which the evidence can be tested. The proposed amendments to IRPA, which would limit the scope of materials produced to special advocates, should be rejected. It is difficult to conceive of what sort of information is being exempted by these provisions. By definition, the information is neither relevant to the government's case against the person, nor is it information to be considered by a judge when determining whether the certificate is reasonable. It begs the question of why this information is being placed before a judge at all, and leads us to conclude that this class of information may be so problematic that rather than being exempted from disclosure, it must be made available to special advocates to review and potentially challenge. It is difficult to comment on national security powers without also discussing the need for real accountability and review, but I know I am out of time. So I will just end by saying this. We cannot afford to enact this bill because we cannot afford to further expand the reach of the scope of our national security activities without taking steps to ameliorate what is now a staggering accountability deficit. Thank you again for this opportunity and for this committee's work, and I look forward to your questions.
Thank you very much, Ms. Chung, and we will now go to Ms. Kerr. You have the floor.
Merci, Monsieur.
Thank you, Mr. Chairman, for the opportunity to speak to you today on Bill C-51, which is a critical piece of legislation. I'm Joanna Kerr, Executive Director of Greenpeace Canada. I'm joined today by Keith Stewart, who is head of Greenpeace's Climate and Energy Campaign.
Executive of ActionAid International, Policy Director with Oxfam Canada, and now with Greenpeace. I have seen firsthand the power of protest and dissent in effecting real transformative change for the betterment of people and the planet. I'd really like to start with a few very simple questions. Would women have the vote today if the suffragettes had not engaged in widespread nonviolent protest? Would racial desegregation in the U.S. have occurred without sit-ins, march-ins, public protests, and people's sustainable resistance to unfair laws? Would despotic governments have been overthrown around the world without people merging onto the streets and holding ground? Would decolonization have happened without nonviolent direct action? All of these movements, and those against slavery and apartheid, to name but a few, employed peaceful but actually unlawful means to confront unjust laws and practice and challenge society's views of right and wrong. They expedited change, which was urgently needed. That is the kind of change which is required today if we are to address the formidable threat that is posed by climate change. Greenpeace's mission was forged in nonviolent direct action, and we have used it to great effect over 40 years. We were instrumental in ending nuclear tests in the waters of the South Pacific, in ending scientific and commercial whaling, in ending toxic dumping in the world's oceans, in getting a treaty to curb acid rain, and in the protections now afforded Canada's Great Bear Rainforest. None of these critical environmental protections would exist without peaceful confrontation, what we refer to as nonviolent direct action. Do we really believe the interests of national security will be served by restricting these fundamental options for civil protest, be it against injustice, corruption, racism, or pollution? Because that is what Bill C-51 proposes in the name of national security. Professors Craig Forsisi and Ken Roach have shown that the bill could be used to target democratic protests engaged in such struggles. And based on public statements by cabinet ministers, as well as leaked RCMP and government documents, there is strong reason to suspect that these powers could and would be used against those advocating for clean water, for precious ecosystems, and an end to catastrophic climate change. We are very concerned that the draft legislation appears to target environmental and First Nation climate activists as a threat to security. To borrow a line from David Suzuki, pollution and climate change caused by excessive burning of fossil fuels and the real threats are the real threats, not the people who warn that we must take these threats seriously. And while we must also respond to terrorism with the strong tools already in place, we have to remember that our rights and freedoms, not fear, are what keep us strong. Greenpeace joins many others in having serious concerns with this legislation. More than 100 legal experts wrote an open letter to Parliament calling on you to amend or kill this bill on the grounds that it is a danger to the rule of law, to protected rights, and to the health of Canada's democracy. They argue that it may be both ineffective in countering terrorism and could actually frustrate anti-terrorism efforts. We share their concerns. And today, I would like to focus on what this bill could mean for democratic debate in this country. The government says the sweeping new powers being granted to CSIS would not be used to target its political opponents. If that is so, then as legislators, you have an obligation to write the legislation so that it cannot be used in that way. This was a key finding of a 2009 United Kingdom parliamentary review of the relationship between policing and protest movements. It stated, the better approach is to draft legislation itself in sufficiently precise terms so as to constrain and guide police discretion, rather than to rely on decision makers to exercise a broad discretion compatibly with human rights. Your British colleagues went on to note that, quote, we are concerned by the reports we have received of police using counter-terrorism powers on peaceful protesters, and to urge that amendments be made to make clear that counter-terrorism powers should not be used against peaceful protesters. As University of Ottawa law professor Craig Forsisi has pointed out, the anti-terrorism law, with its reference to, quote, foreign-influenced activities within or relating to Canada that are detrimental to the interests of Canada, the anti-terrorism law could be used in the case of a, quote, foreign environmental foundation funding a Canadian environmental group's secret efforts to plan a protest done without proper permits, in opposition to, for example, to the Keystone Pipeline project. And we have already seen evidence of this. Government ministers have already characterized anti-pipeline protesters as foreign-funded radicals and even money launderers. A copy of the federal government's oil sands advocacy strategy obtained by Greenpeace under access to information legislation identified environmental and Aboriginal groups as adversaries, while oil companies were listed as allies. It's more detrimental than just name-calling. The 2012 Omnibus Budget Bill not only rewrote Canada's environmental legislation to reduce public involvement in decision-making, but also gave the Canada Revenue Agency millions of new dollars to conduct audits of charitable organizations that disagree with government policy. The Voices Voix Coalition has documented more than 100 cases of recent attacks against those who have simply raised their voices to criticize government policy. Last month, the newspaper La Presse obtained a copy of a secret RCMP, quote, critical infrastructure intelligence assessment that names Greenpeace, Tides Canada, and the Sierra Club as part of a, quote, growing, highly organized and well-financed anti-Canada petroleum movement that consists of peaceful activists, militants, and violent extremists who are opposed to society's reliance on fossil fuels, unquote. Remarkably, this RCMP report downplays climate change. It says that these groups, quote, assert climate change is now the most serious global threat, and that climate change is a direct consequence of elevated anthropogenic greenhouse gas emissions, which, they believe, are directly linked to continued use of fossil fuels, and that by highlighting the, quote, perceived environmental threat from the continued use of fossil fuels, we are fueling a broadly based anti-petroleum opposition. I added my own emphasis there. While the RCMP questions the legitimacy of the threat of climate change, the Pentagon has called climate change as a threat multiplier. The most recent U.S. national security strategy identified climate change as a threat on par with terrorism, weapons of mass destruction, and disease. The World Bank says that it is a fundamental threat to sustainable development and the fight against poverty. And an article published last week in the Proceedings of the National Academy of Sciences found that human influences on the climate system are implicated in the current Syrian conflict. Perhaps most worrying, in light of Bill C-51, the RCMP document categorizes civil disobedience and unlawful protest as being beyond peaceful actions, conflating peaceful activists with those who engage in violence in the category of, quote, anti-petroleum extremists. To be clear, we believe that the threat of climate change must be addressed through peaceful, democratic means. If for any reason someone causes another person harm or damages infrastructure or property, that person should and would, under current laws, face legal consequences. The vast majority of people calling for a debate on fossil fuels and climate change, including those who engage in civil disobedience, aren't violent anti-petroleum extremists. They are school children and grandmothers. They are ranchers and parents. They are people from all walks of life who care.
Over time, would you just wrap up, please?
They care about their family. Yeah. Indeed, the word lawful was struck from the current anti-terrorism law following expert testimony in 2001, so that unlawful activities such as trespass or minor property damage not be conflated with terrorism. So I want to ask you again in closing, do you believe that the interests of national security will be served by restricting fundamental, often vital options for citizen expression and civil protest? We absolutely do not. We asked you to think through these risks.
You're well over time, I'm sorry, but I still have to have some time constraints here, but thank you very much. And we will now go to Mr. Atke, please, 10 minutes.
Thank you, Mr. Chairman. Members of the committee, I'm honored to be invited to appear before you regarding this important bill, which has certainly captured the attention of so many Canadians from across the country and internationally. My interest and background concerning this subject is set forth in my short-form resume, which is attached to my speaking notes in both official languages. So in the interest of time, I'm going to admit that information in my opening statement, although you should feel free to ask any questions. Also, given that the government and one opposition party have already indicated in support principle for this bill, I want to indicate that I am here not to destroy the bill. Rather, I want to assist in proposing some practical amendments that will improve it and perhaps save its constitutional legitimacy and integrity. Like so many others in Canada, I accept, based on known evidence, that the current terrorist threat in Canada to Canada's security is real, and that enhanced measures are necessary for major agencies such as CSIS, RCMP, CBSA, and Transport Canada to combat this threat through lawful means. In the few minutes I have today, I want to deal with 5 important matters. One is constitutionality and the independence of the judiciary. Secondly, I'm going to touch on freedom of expression. Thirdly, on issue of fairness. Fourth, effective review by SERC and others. And fifth is parliamentary overview, which is something you should consider. First, constitutionality and independence of the judiciary. This goes right to the major flaw in the bill. Part 4 authorizes the federal court to issue a warrant to CSIS to take measures that may contravene a right or freedom guaranteed by the Canadian Charter of Rights and Freedoms. This provision, in my view, is clearly unconstitutional, and it will be struck down by the courts. The existing charter already has a built-in limitations clause authorizing reasonable limits where necessary in a free and democratic society, and proportionality applies to those limits based on almost 33 years of charter jurisprudence. If Parliament wants to invoke the notwithstanding clause, it is free to do so under this Constitution, although no federal parliament has had the courage or the need to do so since the charter was proclaimed in 1982. But I ask you, why provoke an avoidable constitutional challenge? Canadian judges are fiercely independent and are not agents of the government who can be mandated to authorize measures at all costs to protect against terrorist threats. Federal court judges have carefully authorized or rejected wiretap applications since 1984 under existing Section 21 of the CSIS Act. I have seen or reviewed some of those applications and judicial decisions. The process of judicial control of wiretap warrants applications works today. Why, in drafting new parallel provisions in Section 12.1 and 21.1 of Bill C-51, respecting additional measures, do you need to instruct the judges to totally ignore the Charter and to allow CSIS to violate constitutional obligations in order to take these additional measures beyond wiretaps? This notion of Parliament authorizing a Charter breach, short of using the notwithstanding clause, is clearly unconstitutional and is not consistent with our constitutional tradition and the way in which Section 1 of the Charter operates. You can avoid this constitutional mess by redrafting Section 21.1 of Bill C-51 to provide that any warrant that permits CSIS to take measures thereunder will not contravene a right or freedom guaranteed by the Canadian Charter of Rights and Freedoms. Now, I have a bit to say on freedom of expression, but in the interest of time, I'm going to jump over that and urge that you consult documents tabled and positions represented before you by my colleagues Craig Forsees and Kent Roach from the University of Ottawa Law School and the University of Toronto. They have dealt with this in detail, and I don't have the time to go through it today. Similarly, the provision of fairness, which is guaranteed by Section 7 of the Charter. Everyone has the right of liberty, life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with principles of fundamental justice. This, ladies and gentlemen, is a provision and the requirement constitutionally of fairness. And it's embodied in the special advocates, and I happen to be a special advocate, so I know a bit about that role. And I think there is a role for special advocates to provide fairness in a number of the warrant proceedings, a number of the no-fly list proceedings, and you should actively consider that. But I do want to jump right into some of the issues that I know are before you and that I know something about, and that's the question of effective review by SERC and others. Now, I have publicly defended the structure of SERC, which was established in 1984 as the CSIS watchdog. and I had the honor to be the first chair. It was effective at the beginning, even though there were growing pains as CSIS broke off from the RCMP and struggled initially to incorporate women and outsiders. The CERC structure has worked where the only body being reviewed was CSIS, and the monitoring of CSIS' extraordinary powers was manageable. That was 1984. But things have changed over 30 years. First, CSIS budget, personnel, and powers have grown exponentially, while the watchdog budget remains pretty much the same. It is unfair to dramatically expand CSIS powers to conduct disruptive or international activities to fight terrorism at home and abroad, while leaving the watchdog frozen in time. Failure of the government to address this issue in the context of this bill, C-51, is irresponsible, and the public has a right to be concerned whether CERC can do the job going forward. Second, this debate on C-51 has caused the public to reflect unfavorably on the scattered and uneven nature of review concerning a variety of federal agencies involved in security matters. There have been concerns about the extent of independent review of the RCMP and CSEC, and the absence of independent review of important agencies such as CBSA, Transport Canada, DFATE, CIC, and 20-odd other federal agencies, not to mention provincial and municipal police forces involved in security intelligence work. Whether we need to adopt a federal security czar to supervise, monitor, and coordinate security agencies, as is done in the U.S., or to develop a super CERC with expanded powers of review and accompanying budget, or to have statutory gateways to achieve accountability as recommended by the O'Connor report in 2006, this is an issue that cannot be left aside as Parliament gallops ahead on C-51. This is not a question of oversight, which has become misused as a term. Responsibility for the planning and conduct of anti-terrorist activities in accordance with the law remains in the first instance subject to ministerial approval and approval by warrants by judges based on court applications submitted by appropriate agencies under the detailed requirements of the relevant legislation. This is oversight. Review bodies do not approve operations in advance, but they do assure accountability after the event to ensure that hopefully all agencies exercising security functions are effective and operate within the law. And they engage the public through exhaustive annual reports tabled in Parliament with a minimum of redactions which are necessary for protecting individuals or methods of operation. Now let me conclude by talking about parliamentary overview. What are the responsibilities of Parliament other than to ensure that Bill C-51 is improved to allow the legislation to go forward and to assist government agencies to deal effectively with the terrorist threat while protecting fundamental rights and freedoms under the Charter? Members, I have been both a parliamentarian and a watchdog, a professional watchdog. And the answer to whether Parliament or a specialized agency should have the power to review security agencies is easy for me. Canadians should have both. Under our system of government, Parliament is the ultimate watchdog and is directly accountable to the people. The party having the most number of seats at each general election usually is called on to form the government, but Parliament itself remains the watchdog. There is nothing inconsistent in having specialized security-cleared watchdogs created by Parliament covering the effectiveness and legality of various agencies involved in security work, and having a committee of security-cleared parliamentarians charged to oversee the whole system. That is, to take an prompt overview of the situation when problems occur, and they inevitably will in this business, and to delegate investigative responsibility to the appropriate specialized watchdog. Indeed, there are 3 bills currently before Parliament calling for a committee of parliamentarians on national security. The one I like the best is Bill S-220, introduced by a former Conservative Senator Hugh Segal, which calls for a committee of 9, 3 from the Senate, 6 from the House, to be appointed by the government but after consultation with opposition parties and the approval by appointment of the resolution of their respective houses. There are provisions for appropriate security and confidentiality of each member of those committees, and the mandate would be to review the legislative, regulatory, policy, and administrative framework for the intelligence and national security in Canada.
Just if you would wind up, please.
I will. Why not absorb Bill S-220 into the discussion and provide for it to come in force on January 1st, 2016? And in this way, I think Parliament could fulfill its position as an effective watchdog, and you could have this in place for a 5-year review process on this bill, which would take place starting 4 years after the bill became law, so that the review could be effective and Parliament could have a major role in the operation. Thank you.
Fine. Thank you very much, Mr. Atke, and thank you to our witnesses for their comments. And we will now go to the rounds of questioning, and we will start off the first round in 7 minutes, and we will go to Mr. Norlock, please, sir.
Thank you very much, Mr. Chair, and through you to the witnesses, thank you for attending today. My first line of questioning will go to the BC Civil Liberties Association. I notice on your website, and I won't mention it, but because it's got all this long, rambling site, but it describes C-51, as you have, as unnecessary. It then goes on to articulate that your group thinks not only that it is unfair. One of the elements of the bill that was attacked is the issue of preventative arrest. This is an item that national security experts and law enforcement officials have stated will be of enormous value in a number of cases. So a high benefit in terms of preventative law, a low cost as it applied to a limited number of individuals. Furthermore, I understand that the preventive arrest provisions in some allied nations, also thriving democracies, go much further than what we have proposed in this bill. That said, it's difficult to fathom a case in which preventative arrests are useful tools for protecting the public. We have heard that radicalization happens faster than we have ever seen in the past. One just has to watch the evening news over the past, I'd say, month and a half to 2 months to see not only in Canada but in many nations that happening. We've also heard that investigations are labor-intensive, and that we have also heard that Canada and its allies are dealing with unprecedented numbers of citizens leaving its borders to commit terrorist acts abroad. And also, sadly, some of these have, and many more have expressed, a desire to turn on their country of birth. In that context, one says, could you really imagine a world in which a weekend in jail would prevent an act of terror and give the government precious extra days to make a criminal case and save Canadian lives? It's also curious as to the concerns of some civil libertarians with an angle like this, that say that basically preventative arrest will only be, we say preventative arrest will only be used on terrorist subjects and prior to preventive detention. The threshold will still be robust because it will require reasonable grounds to believe an attack may be carried out and that the detention is likely to prevent such an attack. No innocent bystander would be caught up in this threshold. An officer must present hard evidence to demonstrate that this threshold is met and that the person in question is a threat to society. Then the Attorney General must agree and consent to the preventative arrest. The arrestee must be taken before a provincial court judge then.
Sounds more like Mr. Norlock is testifying than asking questions of our witnesses.
Mr. Chair, I am entitled to A, make a comment, B, ask a question, but sometimes a question needs to have a certain amount of information before the question is asked. The member just interrupted me so that he could interrupt me. It has no bearing, and he knows his point of order is out of order.
No, all the chair would do, just as in previous conversations before this committee when we asked to keep things relative. At this particular case, it is relative to the testimony that we've heard and where you're going on that. So it is in order, but I would also just encourage all members to try to stay within the framework of the meetings of acceptability for all. Thank you. Yes, point of order, Mrs. James.
I just want to make sure that that interruption does not take away time from Mr. Norlock's full 7 minutes.
That has already been noted. Thank you. Carry on, Mr.
How
Norlock.
much time do I have, Mr. Chair?
You have 3.5 minutes, sir.
Thank you. And just to finish off the last, before the questions I have, the arrestee must be taken before a provincial court judge, as I mentioned, within 24 hours, at which point the judge can extend the detention for up to 48 hours. So the Attorney General then must consent, and then a judge must agree within 24 hours, and there are hearings within 48 hours of that detention. At these hearings, the Crown will have to demonstrate that the case is progressing toward a criminal charge. So we have a peace officer with evidentiary threshold, the Attorney General, represented by Crown prosecutors, the judicial oversight. Keep in mind, we're trying to save lives in an emergency situation. That sounds like a fair process to me. And are there any degree of checks and balances that would satisfy you? Are you simply fundamentally opposed to taking terrorists off the street? And let me just quote one thing before you answer that. Also by one of Mr. John Russell, the then Vice President of the Civil Liberties Association, stated that it is and I quote, "The government's proposed definition of terrorist activity is simply too broad. As it stands, the proposed item," and it goes into 83.011BIIE, "of this definition would count as a terrorist activity any unlawful political motivated act that threatened to significantly disrupt an essential service." He goes on to say that it would potentially brand as terrorists doctors, teachers, nurses who threaten to strike or withhold services in the face of provincial orders deeming their work to be essential service. It could also be branded as a terrorist activity, the actions of First Nations individuals who blockade an airport or highway. So, are you fundamentally opposed to taking terrorists off the streets?
So with respect to that question, and thank you for your question, Mr. Norlock. With respect to that question, no, we are not fundamentally opposed to taking terrorists off the streets. We believe that's necessary to have effective measures for countering terrorism. And our concern with preventative detention is that it may not be the most effective measure for countering terrorism, given that the examples that Mr. Norlock has cited, for example, somebody who might be wanting to travel to go commit a terrorist offense is already in our criminal code a terrorism offense. And so if law enforcement has that information, then it certainly has that information to actually lay a criminal charge, and no preventative arrest is necessary. We have seen, and I think others, even others who do see limited roles for preventative arrest, will acknowledge that preventative arrest it has an enormous potential for abuse. And so to that end, I understand that Professors Roach and Forsees, for example, who I think you'll hear from later today, are suggesting that there be limits to the circumstances under which preventative arrest can happen. And with respect to the characterization that this is simply a weekend in jail, this is not what Bill C-3051 contemplates. As your ministers told, sure. I mean, as I think you heard from the ministers 2 days ago, what this bill contemplates is up to 7 days in detention.
And now, Ms. Leslie, please.
Thank you very much, Mr. Chair, and thank you very much to our witnesses. I'm the environment critic for the NDP, so I really want to focus on Section 2 and the specific exclusion for lawful activity. But before I get to that, I do want to ask a quick question of Greenpeace, because you're an international organization. I'm sure you know you're Greenpeace Canada, but you know what's going on with your colleagues around the world. So how does the laws proposed in C-51, how do they compare to what Greenpeace faces in other countries?
Thanks very much for the question. Certainly, if we compare this law to certainly European countries, that there are protections for both lawful and unlawful protest as an essential part of democratic change. And as I laid out at the beginning of the remarks, some of these critical changes that have been brought about vis-a-vis human rights, social justice, and the environment wouldn't have been made possible without the right to protest.
Mm-hmm. So in drilling down a little bit, because I know, Ms. Kerr, you didn't have a lot of time to get into that aspect of your brief, when I look at Section 2 and this exclusion for lawful protest, and I think, I mean, your examples are incredible, right, and they're inspiring, but I actually think about more banal examples, like when the Raging Grannies came to my office, they didn't have a permit to be on the sidewalk outside of my office, but, you know, they were singing about GMO seeds, and then they came in and we had tea. During the Isle No More movement in Halifax, people descended upon the Micmac Mall in Dartmouth and started a spontaneous round dance. It was nothing but goodness and light. People came out of stores and they danced and they sang, but they didn't have a permit. So I have I agree with Professor Forsizi's analysis of the problem this creates. So Ms. Chung, maybe I'll start with you, and if you can talk first about what impact will this have on groups that are seeking to combat climate change, groups that are concerned about environmental rights?
I think as this committee will hear more of today, the concern is that this law makes no exemption for, unlike the Anti-Terrorism Act as terrorist activity is defined now, it provides exemption only for lawful protest. And I think that as our colleagues at Greenpeace and as Professors Roach and Forsiz have indicated, that's just far too broad. It captures all sorts of peaceful, nonviolent protests, which may simply be running afoul of a municipal bylaw, may not have a proper permit, that sort of thing. And I think that we've heard discussion about how, well, for example, that's not what's really meant. This law is meant to target. It's not really meant to go after the Raging Grannies or kids who are protesting without permit. But I think that approach, and this is something that we set out in our brief, that approach really threatens to politicize what ought to be an objective assessment of security. It makes quite subjective what constitutes a true security threat versus what isn't a true security threat. And for the politically active, I think that that's quite concerning, because whether their conduct would be considered as something that undermines the security of Canada might simply just turn on whether or not their cause is politically popular or not. And so in our view, that's quite dangerous for freedom of expression and for the right to dissent. And so we take the view that the better approach would be to adopt the one that's contained in the criminal code, which explicitly exempts from the definition of terrorist activity all advocacy, all protests, all dissent, and stoppage of work.
Because that's what we're trying to get at here, right, is terrorist activity.
Exactly.
Okay. Mr. Stewart or Ms. Kerr, what impacts do you think that this could have on citizens' efforts to protect the environment and engage on environmental issues?
Well, I think that's our great fear, is that so many of our supporters, seeing the potential of a conflation between peaceful protest and terrorism, that even though this wasn't the intention of the bill, that certainly many legal experts are interpreting it as such, and it does put a real chill in terms of individual and communities' activism. And in a context where there actually is quite a huge deficit of trust with a lot of citizens and their government and some of those government institutions, the extent to which it will harness, it will contract, it will constrain the right for people to carry out legitimate protest against very serious concerns around clean rivers and air and an end to catastrophic climate change.
Yeah, thank you for bringing up the word chill, because that's really important for me, because there is a chill in the environmental movement as it is around protest and speaking out. But I also think about things like in Halifax we had an Occupy in Victoria Park. I went down the day right before folks were getting arrested to talk to them about what their legal rights were, how to not resist arrest, those kinds of basic legal facts. And there was no chill there, but folks really had no idea what their rights were. So it is about the chill, but I think it's also about those folks could be spied on without even knowing, just because they didn't have a permit to be in Victoria Park. That's what we're talking about here, right?
Do you want to jump in there, Keith?
Yeah, I think the ability, given the context right now, there is a great deal of conflict over what to do about climate change. Given that this is one of the defining issues of this century, there should be. And an attempt to put a chill on those types of protests when, people who have protested against pipelines have already been spied upon, as you will hear. We've already had statements from government ministers which very much equate this movement as being anti-Canadian, including from the RCMP. It's the anti-Canada petroleum movement, which I'd never heard of before. We shouldn't be trying to limit democratic discussion, even when it is intense. That is a part of being in a democracy. That is our right as Canadians. There are laws to deal with things like illegal protests. We don't need to conflate those types of protests with terrorism, which is why your British colleagues say separate policing a peaceful protest from anti-terrorism. And that is what should be done.
Mr. Stewart, and we're over time now, so we will now go to Mr. Payne, please. 7 minutes.
Thank you, Chair, and I thank the witnesses for coming and to talk about this very important bill. I will be sharing my time with Ms. James, and I'd like to let her go ahead of me before I finish up.
Thank you, LeVar, and thank you, Mr. Chair, and to our witnesses. I just wanted to correct some of the misconceptions that I've heard so far in this committee. I'll start with the information sharing. There seems to be an implied belief that someone who is protesting lawfully or perhaps unlawfully because they don't have necessarily a municipal permit would somehow come under the scrutiny of being spied on. That's absolutely not the case. The aspect of this bill has 5 different parts. The first one is information sharing. Has absolutely nothing to do with law enforcement, the RCMP or CSIS. It's the ability for agencies to be able to share information between one branch of the government to another. And it's also a 2-pronged approach as well. If you actually read the bill on page 3, it specifically states, for greater certainty, it does not include lawful advocacy, protest, dissent, and artistic expression. Now, some of the concerns I've heard has been, well, what if it's unlawful? What if there's no municipal permit? The fact of the matter is that you look clearly at the bill. In that same section, it talks about the purpose of the Information Sharing Act, and it has to do with activity that undermines the security of Canada, activities that undermine the sovereignty, security, territorial integrity of Canada, or the lives or the security of the people of Canada. So unless your unlawful protest is somehow going to include blowing up infrastructure, I think that you're misinterpreting this section of the bill. But the second thing that I wanted to clarify before I pass it over to my colleague, Mr. Payne, has to do with the preventative arrests, detention, and the extension of the 24-hour period to up to 7 days. It seems to have been implied that someone is just going to be simply thrown in jail, and the police officer or the investigator that initiated it is someone going to, leave on vacation. That's simply not the case. They actually have to have the consent of the Attorney General. It has to go before a judge. The judge has to review all of the evidence that would warrant someone to be detained for 24 hours. And then it's actually a review period every 48 hours after that, up to the maximum of 7 days. So in that period, the person who has brought this before the judge to seek this type of detention actually has to prove that there is an ongoing investigation, that they're accumulating information, has to prove the reasons why there has been a delay. This is all necessary. This has clearly been identified by our national security agencies. In fact, on Tuesday's committee, we actually heard that these types of measures are absolutely critical to the RCMP in order to carry out their investigations. So I just wanted to clear those 2 things up on that I've heard so far as misconceptions of the bill. And I now will pass my remaining time over to Mr. Payne. Thank you.
Thank you, Ms. James. And certainly she touched on some of the areas that I wanted to touch on, but I guess what I want to say that this information sharing power enables for national security purposes. And it doesn't compel any government or any one arm to share with another one if they don't want to. And also, for your information, and I don't need to repeat it twice, but it's subject to the Privacy Commissioner's review. Okay, so there's another pillar there that certainly protects individuals. Anyway, the purpose of the Act is sharing for national security threats. So it makes me wonder if your organization is a national security threat. I see your organization as protesting pipelines, forestry projects, but I didn't hear anything to indicate to me that you were planning to bomb any of Canadian infrastructure or sabotage electrical grids. So I wonder if you consider yourself to be a national security threat, and if you understand the definition, that it won't apply to you as long as you don't commit any of these terrorist activities. So that seems to be fairly clear to me. And I think Minister Blaney was also clear on Tuesday that lawful and unlawful protest will not meet the threshold for information sharing. And I'm sure you are aware that there are 2 tests, again, to make sure that that information sharing can take place. And first to point out that the information is not a collection of new information, it is a sharing of current information and has nothing to do with the arrest or prosecution. So even if your protest is interfering with critical infrastructure, that is only one test. And a very important and pertinent second test is to whether or not the protest is undermining the sovereignty, security, or territorial integrity of Canada, or the lives of the security of the people of Canada.
Mr. Payne, I'm sorry, but we are out of time, sir, and I'm sorry you're just getting started, I realize, but we have expired through our first hour of testimony, and certainly I would like to express regrets that we all haven't had an opportunity. Point of order, Mr. Easter.
Yes, Mr. Chair, one of the parties in this lineup hasn't had the opportunity to question witnesses, and that's really problematic. I understand we're out of the first hour, but if the hearing process is going to eliminate the ability of one of the parties to raise questions, then we've got a severe problem.
Go ahead. Well, thank you very much. Another point of order. Point of order taken. Speaking to the same point of order, Mrs. James.
Thank you. I was just going to possibly make a suggestion that we limit the opening remarks instead of having it up to a maximum of 10, that we perhaps reduce it down to 7 or 8 minutes in order to accommodate the third party.
Okay, what the chair is suggesting, and this is what the chair had in mind, I understand Mr. Easter's point on it is a valid point. No one wants to be excluded from having an opportunity to question. There were 2 problems. One, of course, we had the point of order first by Mr. Easter, which took some significant time away from the opportunity. However, that being aside, I think in all fairness, what the chair is prepared to do at this particular point is suggest that when our next witnesses come, the chair will encourage them to be as short as possible, and then to take a look at the time that is left after that and spread it equally amongst the 4 parties, the 4 original first round people. That is the chair's decision as to where he is going to go on this issue. So the questioners might get 7 minutes, the questioners might get 5 minutes, depending on the time that is left. But at least our first full rounds of questioners will be available so that each party will certainly have their opportunity. If you have a point of order, I would like to move on to our next witnesses, and if you wish to start your point of order prior to that, but at this point, the chair would like to suspend. On this point?
Yes.
Okay, go ahead. Yes, Mr. Garrison.
Well, this is exactly the concern we raised with the government when we're setting the number of witnesses, and we objected very strongly to having 3 witnesses per panel because of exactly this problem. And so when we've invited people here to give their testimony, we're now going to cut them short, and we're going to cut the questioning short. And I just want it very clear on the record that this is a result of the government's insistence on having 3 witnesses per panel instead of 2 witnesses per panel, as we thought would be appropriate.
Well, thank you very much, and the chair will just simply not respond accordingly, other than the fact that it has been the practice of this committee on most occasions to have up to 3 witnesses, and so this is certainly not an exception. It has been normally the rule, but the chair would like to move on. We have other witnesses to hear, unless there is a point of order on the same point the chair is willing to rule. Yes, Ms. James.
Thank you, Mr. Chair. The guidelines that are set out for this committee that the entire committee as a whole had agreed upon basically scheduled the time for questions to be the first round 7 minutes for the Conservatives, 7 minutes for the NDP, 7 minutes for the Conservatives, and so forth. It goes in that rotation. So I would like to request that we stick to those original guidelines, as we've done in the past when we've had 3 witnesses, which is the standard practice of this committee, to have 3 witnesses per hour. That's nothing new. It's what was agreed upon, that we just reduce the length of the opening remarks to 7 or 8 minutes, which would certainly accommodate the ability for the third party, the lone individual Liberal, to have a chance to ask some questions.
The chair will do what the chair can do to try to provide some balance there. So we will now suggest that we will suspend to bring in our next witnesses and thank our witnesses for coming here. Your appearance is very much appreciated. Thank you very much.
Do you want a cup of tea?
Okay, Ren, ready to go. Okay, colleagues, we will resume and welcome our 3 witnesses for this for the second hour. We have with us, of course, Paul Champ, counsel from the International Civil Liberties Monitoring Group. Welcome, sir. And as an individual, we have Barry Cooper, professor of political science at the University of Calgary. And we have from the Assembly of First Nations, the Chief, Perry Galgreen, National Chief. Welcome, welcome all. Gentlemen, we are running tight on time, and I recognize we cannot ask you to change your opening remarks and bring right down briefly, in that would not necessarily be fair given the opportunity that you haven't been told. So in the future, this committee could perhaps suggest eliminating the or reducing the opening remarks, but for this particular point, all I would ask is your courtesy to try to make them as brief as possible. And so we will now, and then of course, as the chair has mentioned, the round of questioning for the first round will be split accordingly. So we will go at this point then, and we will start off with Mr. Champ. You have the floor, sir. Up to 10 minutes, but preferably significantly shorter.
I'll see what I can do. Thank you very much, Mr. Chair. And I want to thank you, Mr. Chair, Mr. Clerk, and honourable committee members for the privilege of this invitation. I'm appearing on behalf of the International Civil Liberties Monitoring Group, which is a pan-Canadian coalition of over 40 NGOs, faith groups, and trade unions. It's been involved in national security and civil liberties issues since 2002. Personally, I'm a human rights lawyer, and I've been involved in many national security cases where civil liberties and human rights have been violated, and so I have quite a bit of background in this area myself. I'm going to touch on 3 issues, 3 bills. I'm going to speak to the information sharing bill, the no-fly regime, and the expanded powers for CSIS, that is, the powers that are going to allow the secret authorization for CSIS to violate fundamental human rights for Canadians. We'll also have a written brief that we're going to provide in more detail these points that we're making. Obviously, with the footnotes and references are always great to have, but I'm just going to try to hit the high points for you this morning. First, the Security of Canada Information Sharing Act. From our perspective, there's 2 novel features to this act. The first is the expanded definition of Security of Canada. This is a new definition that is unprecedented in our legislation. What we have right now for Security of Canada is in the CSIS Act, Section 2, which is then incorporated in about 10 other statutes. In Canada, we refer back to the definition in the CSIS Act, and what has been truly surprising for many critics looking at this bill is trying to understand why the definition for Security of Canada has been expanded. If the point is to capture terrorism, terrorism is captured by the CSIS Act definition. This bill has 9 enumerated activities, and terrorism is only one of those. So if the true target of the bill is terrorism, why are we expanding it? And, you know, with great respect, I heard the minister's testimony the other day saying, well, it's not meant to capture advocacy and dissent. Well, if that's the case, then why change the definition? Because the Security of Canada definition in the CSIS Act was more than adequate, which was serious acts of violence, attempts to violently overthrow the government, and espionage. That has been the definition in Canadian law for over 30 years. Why change it now? The second point that we have with Security of Canada Act is that it is dropping the walls around privacy across government, and it gives a mandate to government officials in all of these departments to basically spy on Canadians. If you look at Section 5 of this Act, it is asking all government departments to act and try to prevent, detect, identify, and disrupt activities. These are going to be government officials who don't have experience in law enforcement or security intelligence. Like, you know, what does a tax auditor know about disrupting terrorism? That's what this bill is doing. It's turning all government employees into spies, and it's going to facilitate the creation of secret files on Canadians because someone feels that, you know, a person's lifestyle or opinions or travels are suspicious. And there are harms and risks associated with information sharing. I mean, information sharing is such a benign phrase, and I can tell you when I first encountered it as a lawyer, I was like, well, what's the big deal? But I have encountered many cases and have acted on individuals whose lives have been devastated because of improper and erroneous information sharing by Canadian government officials. It can have devastating consequences. We've had 2 public inquiries in the last 10 years in Canada dealing with 4 Canadians who were tortured, brutally tortured by foreign officials based on erroneous information sharing by Canadian officials. That's not my opinion. Those are findings by 2 public inquiries paid for by Canadians. Just last week, committee members, I settled a case with the Government of Canada on behalf of an Algerian refugee and aerospace engineer who spent 5 years wrongfully imprisoned in the United States and seriously abused as a 9/11 suspect because of erroneous information sharing by Canadian government officials. Last week, the Canadian government finally righted that wrong and settled with my client, but those are the kinds of consequences that are associated with information sharing. When you don't have proper controls and regulation over information sharing, it can have devastating consequences on individuals. The O'Connor inquiry involving Maher Arar had excellent recommendations for that, saying that, you know, we have to have controls and filters to ensure that there's relevance and reliability for the information prior to being shared. We don't have those safeguards in this bill. Secure Air Travel Act. This is the no-fly regime. The client that I act for, the International Civil Liberties Monitoring Group, has been one of the most active groups in studying no-fly list since it was first introduced in Canada in 2007. We know that in 2007 there was over 2,000 Canadians on the no-fly list, the Canadian no-fly list. That was announced by the government. Ever since, the International Civil Liberties Monitoring Group has been asking the government and Transport Canada repeatedly how many Canadians are on that list. Just the numbers. The government has repeatedly refused to provide that number, and I think if this committee is going to seriously consider this bill, you should be asking government officials to at least tell you how many people are on that list right now, how many Canadians' rights are being put at risk because of this bill, and why are you refusing to tell Canadians? That's an answer that you need. What I can tell you about the existing regime is that in 2007, all privacy commissioners in Canada, not just the Privacy Commissioner of Canada, but all provincial privacy commissioners, issued a joint resolution saying that the current passenger protect no-fly regime is too opaque and violates the privacy rights of Canadians. All privacy commissioners in Canada. In 2008, the Privacy Commissioner in Canada issued a report that Transport Canada had provided, quote, no evidence demonstrating the effectiveness of no-fly lists, despite her repeated request for such information. Those comments are more valid today than ever. This regime has been in place for 8 years, and we have no information about its effectiveness, about how many people are implicated, and why we need to expand it today. The problems with the no-fly regime as it existed and as it will be in this new Security of Air Travel in Canada Act, or the Secure Air Travel Act, is that there's no due process protections whatsoever. You don't get any notice that you're put on the list, and once you do find out, you can't challenge the evidence. It's completely secret, and you don't have the right to see or challenge the evidence. This regime, as it currently stands, was already found in 2008 by the Office of Reconsideration. That's the a review body that this government created to review listing regimes. That body decided or ruled in 2008 that it violates Section 7 of the Canadian Charter of Rights and Freedoms. Transport Canada has ignored that finding, and as of yet, no Canadian court has considered it, but I can tell you as a constitutional lawyer, I'm quite confident that will be struck down. I can tell you that last year, 2014, the U.S. courts found that the U.S. no-fly regime violates their Fifth Amendment of their Constitution, which is the equivalent of our Section 7 of the Charter. So why are we doubling down now and enhancing and expanding this unconstitutional power that violates Canadians' rights? The final issue, the CSIS Act, the expansion of powers, the extraordinary expansion of CSIS powers that allows our spies to violate the fundamental human rights of Canadians. That's what it allows. It allows CSIS agents to violate charter rights or disrupt their lives, all in secret. The big thing about this bill, this part of the bill, is that it's blurring the line fundamentally between law enforcement and security intelligence, and it overrides the primary purpose why CSIS was created in the first place. The agents in CSIS used to be part of the RCMP, and they were separated out from the RCMP precisely for this reason, so that we keep operational activities separate from security intelligence activities, because the overlap can lead to dangers for civil liberties of Canadians. Why are we rolling back the clock? Why are we completely throwing out the very reason why CSIS was created in the first place? These powers have no real limits. The only limits in the Act is that you can't cause death, you can't cause bodily harm, and you can't violate sexual integrity. Everything else short of that, it's up to the imagination of CSIS agents. It could include detention. It could include secret sites of detention, the black sites that CIA had. That's technically authorized by this Act. It also, well, if we don't want to allow that, put detention in the bill. If it's not meant to cover that, put the detention in the bill. The final thing is that with these warrants, it's going to allow warrants, and Mr. Aki testified before about how it creates problems with judicial independence. But here's one big thing I'll tell you that you may not hear from other witnesses, is that it relies on the candor and good faith of CSIS agents to put forward the proper information to those judges, because those warrant hearings are completely in secret, the judgments will be in secret, and we won't know.
Camp,
But just, if I could just make the one last...
No, I'm sorry, sir. We're already over time. We will now... You're over time, sir. I'm sorry. Please respect the time commitments of the committee here. You're well over time now. The chair has been extremely lenient. We will now go to Mr. Cooper, please.
Well, thank you, Mr. Chair, and thanks for the invitation to appear before this committee on such an important matter. It will be obvious enough that I'm not a lawyer. I'm a professor of political science at the University of Calgary. Among other things relevant to your deliberations, I've written a book on terrorism as a political religion, major reports on why we need a foreign intelligence service, on the RCMP, and on problems that democracies have in fighting small wars. By and large, I think C-51 is a useful improvement on Canada's anti-terrorism legislation. I said so in a couple of newspaper columns, and I won't repeat myself here. I have some critical and analytical remarks which I expect are more useful for your purposes rather than half-heartedly praising the government. Let me begin by recalling that the Prime Minister introduced C-51 in Richmond Hill last January with the words, "Violent jihadism is not a human right, it's an act of war." I think this is fundamentally accurate. We are in a different threat environment today than we have been previously. The problem of terrorism is not one of simply violent extremists, as President Obama said, but chiefly of violent jihadis. That being said, I recognize that as in any law of general application, C-51 has aroused the anxieties of Canadians concerned with peaceful and sometimes not so peaceful protest and how this activity will be treated under the provisions of C-51. However, the chief conflict, I would say, is not between the police and criminals. In order to understand the main threat to Canadian security, it's important to look first at how the opposition understand themselves, and they say they're at war. In a study published last year by Clark McCarley and Sophie Mokolenko, the authors deal with the importance of the jihadi narrative, which they argued move often isolated individuals from radical opinion to radical action. Two things are important here. The first is a four-part jihadi narrative. First, Islam is under attack. Second, jihadis are defending Islam. Third, their actions, which we call terrorism, constitute religiously justified warfare. And four, the duty of Muslims is to support their actions. And second, about 5% of British Muslims where this study was conducted agree entirely with this narrative. 80% agree with the first element, that Islam is under attack. And the authors think that this is a low estimate. I mention this at the outset because the liberties of Canadians because the liberties of Canadians are threatened a lot more by Islamic State than by CSIS or the RCMP. C-51 contemplates changing CSIS into something more than a security intelligence service, but less than a foreign intelligence service. Fortese and Roach, from whom you'll be hearing later, and both are critics of C-51, call this a kinetic service, and that seems accurate enough to me. For what it's worth, I support a dedicated foreign intelligence service, real spies dedicated to stealing secrets from other countries. This new CSIS may be a step down this road, but if so, it needs eventually to deal with a fundamental problem. Catching spies or neutralizing threats requires an entirely different skill set than espionage and associated extra-legal or illegal operations. Historically, the separation of spying and spy catching has been the rule among democratic regimes because the operational focus and organizational culture of such operations are so different. What a newly kinetic CSIS will be like is not at all clear, which introduces a second problem that it seems to me is equally intractable. It's not possible to harmonize the purpose of the police with that of security intelligence, though it may be possible to manage their incompatibilities. Part 1 of C-51 on information or intelligence sharing seems to address this tension between CSIS and the RCMP. Let me say that intelligence sharing is useful and even necessary, and Part 1 is a good start. That said, the underlying tension has not disappeared for the simple reason that intelligence and police organizations have distinct and sometimes conflicting purposes. Police want to arrest suspects and gain convictions in court. Intelligence organizations want to play suspects for additional intelligence. Police need to be scrupulous in following legally correct procedures of gathering evidence, for example, to ensure convictions. Intelligence operatives who are not primarily interested in convictions do not. This tension cannot really be dissolved since it goes to the heart of these different kinds of organizations. How CSIS and the RCMP will ensure that disruptive or kinetic activities of the former do not also disrupt the criminal investigations of the latter is a problem. Personally, I would hope that CSIS intelligence gathering, except in emergencies, trumps their kinetic activity, which in turn trumps the RCMP. This is more or less what Bill C-44 proposes, I believe. If so, I'd say it reflects the appropriate priorities of the two organizations. One other thing I would mention deals with oversight and review. As with the distinct purposes of police and security services, there is a distinction to be made here as well. Where CSIS's contemplated activities would violate the law, a federal court judge must pre-approve them with a warrant. This adds something of oversight by taking it outside the executive chain of command. I would reserve judgment as to whether we need additional oversight beyond search and surveillance warrants until we see how the proposed structure works. But how will we know how it works? This is a matter not of oversight, but of review, of after-action audits similar to what SERC, the Security Intelligence Review Committee, is currently supposed to do with CSIS. I say supposed to do because I'm sure you know this review agency is underfunded and understaffed. Worse, if there's to be a whole-of-government approach to security and intelligence sharing, as is contemplated by C-51, which, as I said, is a laudable objective, then there needs to be a whole-of-government approach to reviewing what the government agencies do. Currently, for example, Canada Border Agency, which conducts both police and intelligence work, is not reviewed by anybody. This is bad bureaucratic practice, to say the least. I would suggest, therefore, an expansion of the SERC model. But as in the case of the UK and Australia, I would add to the specialists and the technical officers and people like Mr. Atke, sitting MPs from both sides of the House. This seems to work fairly well in Australia, so far as I know. Obviously, the MPs, like other SERC members, would have to be sworn to secrecy. I'd point out two further things. Secrecy in review of intelligence operations is as inevitable as it is in spying and conducting security intelligence. No country can conduct intelligence operations, whether defensive or offensive, in public. And second, increasing oversight is not as important as increasing after-action reviews. The reason is, one, that more oversight amounts to more interference with the executive in matters where intelligence activities are often time-sensitive, and two, after-action reports will influence future expectations, which is a kind of internal oversight, by providing appraisals of how the various security services behave. C-51, in short, is a good first step, but it can be improved. So finally, thank you for your attention. I'm happy to answer a few questions later if I can, and I hope I've not said too much.
Actually, you're well under time, so thank you very much, Mr. Cooper, and we will now go to Chief Bellegarde. You have the floor, sir.
Thanks, Mr. Chair. Good morning to you and the honourable committee members. Again, my name is Perry Bellegarde, and I'm Chief of the Assembly of First Nations. Regarding Bill C-51, Bill C-51 is the subject of a great deal of commentary and controversy. First Nations have a long history in this country of dealing with laws that threaten our rights, so we are always on guard against any legislation that could affect our rights, our citizens, and our traditional territories. The key issues at stake in Bill C-51 are the state's power to place individuals or groups under surveillance, to monitor their everyday activities, to create criminal offenses that affect our ability to exercise our legally recognized rights, and the overall relationship of state power to fundamental human and Indigenous rights. On these issues, First Nations have expertise and hard experience to offer this committee, the government, and Canadians as a whole. First Nations people are often forced to take a stand against actions or initiatives by governments that refuse to respect or protect our rights. These activities are often deemed protests, when in fact we are only calling on Canada to obey its own laws, which include the recognition and affirmation of inherent and Aboriginal rights and treaties in Canada's own Constitution. At the core of this discussion for First Nations is the unfinished business of balancing federal and provincial laws and authorities with the inherent jurisdiction and sovereignty of First Nations. At its core, this discussion is about reconciliation. reconciling Canada's claims to sovereignty with our pre-existing rights, title and jurisdiction, and Canada's ongoing treaty obligations. We need to finish that work. It's the way forward, but until we do, First Nations as individuals and as nations will assert our fundamental civil and political rights. We've had to do this many times in the past in the face of a history of imposed, oppressive laws, laws that we are always told are good for us and good for Canada, but in fact they were outright attacks on our identity and our rights. We have suffered under laws that banned our cultural and spiritual practices, laws that denied our right to vote, laws that prevented us from going to court to fight for our rights, laws that gave the state the power to steal our children and assault their minds and bodies, to try and kill our languages and traditions. We have been subjects of surveillance and suspicion and seen as a threat for as long as this country has existed. Why? Because our cultures, our values and laws place a priority on protecting the lands and waters. They place primacy on sharing and sustainability. Canada knows that our existence as peoples and nations qualifies and calls into question its claims to absolute sovereignty. But our people survived and prevailed over all the assaults against us because our ancestors and elders stood up for our people and our rights. And this generation is not going to forsake our ability to protect our lands and territories and rights that have ensured our survival. We will continue to assert our inherent sovereignty and sacred responsibility to protect the land and the waters. We have the right to be decision makers in any activities that affect our lands and territories. Our laws and legal traditions embrace a balanced view of security, development, environmental protection, and fundamental rights. We have deep and strongly held traditions that respect individual autonomy, freedom of speech, and how to balance these for the collective good. Canada can learn from this. That is the history and perspective we bring to this bill. We believe in the right to safety and security, but the federal government's rush to ram this legislation through is undemocratic and it violates our individual and collective rights. We have many concerns with this legislation. First, the proposed Security of Canada Information Sharing Act sets out an overly broad definition of activity that undermines the security of Canada. We see this as a euphemism for an excuse to spy on First Nations when they exercise their collective and individual rights. Our people could find themselves under increasing surveillance because of the broad, vague concepts and activities covered by this phrase. It clearly goes way beyond the current criminal code definition of terrorist activity. The For Greater Certainty clause that excludes lawful advocacy, protest, dissent, and artistic expression is not adequate to deal with complexities of the ongoing task of reconciling First Nations law and jurisdiction with Canada's asserted sovereignty. This government often invokes the rule of law. We would like some rule of law that respects our Constitution, our constitutionally protected rights, and our fundamental human rights. The days are gone when absolute parliamentary supremacy trumps human rights and First Nations rights. But we still see this government struggling to accept the Constitution Act of 1982, both Part 1, the Charter, and Part 2, which recognizes and affirms our treaty and Aboriginal rights. Both sets of rights are at stake in Bill C-51. First Nations maintain that Bill C-51 will infringe our freedom of speech and assembly, our right to be free of unreasonable search and seizure, our right to liberty, our fundamental rights as peoples under Section 35 of the Constitution Act 1982, our treaty rights and our right to self-determination. Our right to self-determination, recognized in the United Nations Declaration on the Rights of Indigenous Peoples, includes the right to protect and make decisions about activities and laws affecting our lands and waters. But there is a balance between rights and security, and we can find it through dialogue with one another as nations. Unfortunately, the process for developing this legislation did not meet the federal government's duty to consult and accommodate, and on that point alone is subject to challenge in the courts if the government tries to impose it on us. Bill C-51 sets up conditions for conflict by creating conditions where our people will be labeled as threats to critical infrastructure or the economic stability of Canada when asserting their individual or collective rights as First Nation citizens. This is not an abstract argument for our people. We've been labeled as terrorists when we stand up for our rights and our lands and our waters. we can see how First Nations have been lumped in with terrorists and violent extremists when they are asserting their fundamental rights and jurisdiction, as in the recently leaked RCMP memo entitled Criminal Threats to the Canadian Petroleum Industry. I'll be submitting this report as part of this presentation. First Nations have an unmatched record as peaceful peoples in the face of the most appalling human rights abuses, which is particularly exceptional when we remember the unrelenting assaults on our values, laws, jurisdiction, and fundamental human rights. We are peace-loving peoples, but we will push back against assaults on our most basic liberties. We stand with the many other Canadians who are not willing to forfeit their fundamental rights and freedoms, who are demanding that this government engage in more careful crafting of important legislation. Canada must do better and must do more to meet its constitutional and treaty responsibilities to First Nations. I leave you with a statement directed not just at this committee but to all Canadians. First Nations know better than anyone how easy it is for government to ignore, erode and eradicate our most basic human rights and freedoms until you barely recognize the land you're living in. First Nations deserve better. Canadians deserve better. We cannot turn back. We cannot turn our backs on our hard-won human rights, and we cannot turn our back on the Indigenous rights. Treaties and title on which this country was founded, we can do better and we must do better. First Nations will vigorously oppose any legislation that does not respect and protect our rights. First Nations will stand up for the rights of our people and our responsibilities to our traditional territories. We make the following recommendations. Number one, that the government withdraw the bill and consult properly with First Nations about its impact on our rights. And number two, that the government discuss with First Nations options for a review process to examine all federal legislation that can impact the assertion of our Section 35 rights. Thank you.
Thank you very much, Chief. And we will first go to our round of questioning then, 5.5 minutes each. And so we will go to Mr. Blonsky, please.
Thank you, Mr. Chair. Thank you to the witnesses who have obviously put a great deal of thought into sharing their concerns and perspectives. I have and am doing quite a bit of reading in order to gain a deeper understanding of exactly why we are bringing forward this bill and the concerns that animate it. I've read a very interesting article that I recommend called What ISIS Really Wants, which is in the March edition of The Atlantic. It's by Graham Wood. And I've also read an interesting article from the New York Times called The Education of Jihadi John. This article says that Jihadi John, I think we mostly know who he is from watching the news, was a graduate in computer science from the University of Westminster. He says, quote, "In fact, academic institutions in Britain have been infiltrated for years by dangerous theocratic fantasists. I should know. I was one of them," he says. The writer of the article says that his recruiter came straight out of a London medical college. He says that while such institutions must guard free speech, they should also be vigilant to ensure that speakers are not given unchallenged platforms to promote their toxic message to vulnerable populations. And he ends by saying, until we confront this seeming legitimacy of Islamist discourse at the grassroots, we will not stop the scourge of radicalization. So I ask you, Mr. Cooper, as someone who is in the academic world and has done a great deal of study, whether this is a concern not just in Britain but in Canada.
Well, yes, thank you. First of all, I'd like to say it's somewhat gratifying to see that other than academics are concerned with the problem of politicized religions, and to see papers like that one in the Atlantic or in the Times is something of a novelty. For those of us who've been looking at the sources of terrorism, the recent waves of terrorism, most of the analogies are made with medieval apocalyptic movements that believed that they were going to transform the world. the entire world by introducing basically new realities that were taken from the Book of Revelations. Now, in the Islamic world, there are equivalent symbolisms to what we're probably more familiar with. And that Atlantic article I thought was actually quite accurate. And it's also something that many of the more radicalized Salafist Muslims think they can actually bring about. They can bring about the Mahdi coming out of what is now Afghanistan and Iran to undertake a kind of final Armageddon-like battle in all places in Jerusalem where Jesus is going to help them. So these are exactly millennial fantasies in our common sense world, but they motivate many of these people, and it's something that academics have known for a long time, and it's really quite gratifying to see that this makes it into these wider media of distribution.
While we are confronting this threat, clearly we need to do so in a prudent and measured way, one that respects Canadian values of freedoms. And Mr. Champ and Chief Belgrave had mentioned some concerns, and Chief Belgrave said, and I think it's understandable, that he and his organization want to be on guard to protect rights and freedoms for First Nations, and I hope for all Canadians. The minister was asked about this in committee earlier this week, and he said that the act, this draft act, clearly states that the definition of activity that undermines the security of Canada does not include lawful advocacy, protest, dissent, or advocacy expression. He said it has to undermine the security of Canada. And he also said that lawful intent is intended to be read narrowly, which it is already in RCMP activities. I noticed, Professor Cooper, that you've written about this issue of undermining the security of Canada. I think it would be helpful in light of concerns that have been expressed, what your understanding is of what it would take to meet the test of undermining the security of Canada.
I'd love to hear the response on that, but we are over our time on that. So we will go now to our next questioner. Perhaps in the next round of questioning, Mr. Cooper, you would have that opportunity. But at this particular point now, we will go to Ms. Ashton, please.
Thank you, Mr. Chair, and I want to thank National Chief Bellegarde for joining us today and for sharing his powerful presentation. And I'm sorry there wasn't more time to hear your comments to my Conservative colleagues' questions across the way. National Chief Bellegarde, you are the first Indigenous witness, and as the National Chief, you speak on behalf of many across this country on what Bill C-51 will do to Indigenous peoples and Indigenous communities. I have a few short questions, and given our restricted time, I do want to ask you first, does Bill C-51 pose a threat to Section 35 rights?
Yeah, it does. It does, and I outlined earlier on, there's a duty to consult and accommodate. When any law that's going to be proposed by the Crown will affect Section 35 rights. And again, there's an obligation, and it's been proven as well in Mikisew Cree, Chief Couture's case that was won, that when any bill is developed, notice has to be given, and there has to be a proper opportunity for responses, to that bill. And that didn't happen in this case. And so I pointed that out in my presentation, that there will be legal challenges because of that.
Thank you. Second, you referred to it in your speech, but I'm wondering if you could elaborate. According to you, does Bill C-51 seek to criminalize dissent and Indigenous dissent and the expression of Indigenous peoples of their rights and of their title?
Well, that's the biggest fear and concern, that just because we're going to stand up to protect the land and our water on any development, that we could be branded as terrorists. And I think of the anti-fracking position that Elsie Book took. Are the people terrorists because they're trying to protect the water? I think of even the Site C flooding in northern BC that's proposed. If the people there start standing up against that initiative, are they going to be branded as terrorists for trying to protect their hunting territories where they used to trap, fish, and hunt and gather? Are they going to be labeled as terrorists? I think of in northern Manitoba, Bipole 3, where they're clear-cutting the forests. You know, the Chief Janai is standing up against that because that's where they used to hunt, fish, trap, and gather. Same thing. Are they going to be branded as terrorists if they try to say, hey, we have rights here? You know, by going ahead with these developments, it's going to affect them. So that's our biggest fear, when our people are starting to stand up for their rights, that they will be branded as terrorists when they're not. They're just standing up for their fundamental inherent rights, treaty rights, Aboriginal rights, and they should not be branded as terrorists because they're protecting the land and the water.
Thank you. National Chief, I know you are aware of the facts that have come to light over the last few years about the incredible rates of surveillance of Indigenous activists and Indigenous grassroots organizations in this country. We're aware that even a few years back in 2009, it became clear that the RCMP intelligence unit was reporting weekly to approximately 450 recipients in law enforcement regarding the activities of Indigenous grassroots movements. Is this a reason for concern for you that might point to what Bill C-51 could do only more of with regards to surveillance that clearly already exists?
See, again, I referenced that in my comments again. The unnecessary surveillance, the infringement on privacy issues, and again, just people following around. I think of the example of one of our heroes, Cindy Blackstock, you know, which was standing up for children, you know, and the discriminatory funding on reserve for child care. She was followed around and just surveillance, like just unnecessarily. Her privacy was brought into question so many times unnecessarily. And I think there's going to be too much powers given to the agencies, government agencies, with this bill that will really be abused and infringe on that individual right. And a lot of our people will be followed unnecessarily, just again for standing up for things that are right, things that are just, and that's why we're looking at opposition to this bill legally if it goes through.
And finally, depending on the time, but I do want to ask National Chief, what are you hearing from First Nations leaders, but also grassroots members? Do you hear any support for what Bill C-51?
No, not at this point in time. Again, it's most of the responses that we're getting from our chiefs and leaders from across Canada that they're opposed to it because it's going to impact on our rights. And we don't want to be labeled as terrorists in our own territories, our own homelands, for standing up to protect the land and waters. That's the message we're getting pretty loud and clear from right across Turtle Island.
Great. Thank you very much. Any final comments, National Chief?
No, again, I think the recommendations and to government is to withdraw it and engage in a process with us. So that, and again, it's not just Bill C-51, Bill C-38, Bill C-45, the omnibus bills that really impact on Section 35 rights. We can work these things through, but let's establish a meaningful process and dialogue so that we can get it right, because everybody in Canada deserves to get it right and done in a good way. So that's our recommendation, to withdraw it. Let's engage in a respectful process and get it right.
Fine. Thank you very much, Chief Bellegarde. Thank you, Mr. Ashton. We will now go to Mr. Falk, please. 5.5 minutes.
Thank you, Mr. Chair, and I'd like to begin by sharing my time with Ms. James.
Thank you very much. I just want to respond, Chief Bellegarde, some of your comments. And I appreciate you coming today to express your concerns because it gives me an opportunity to respond directly to that. I just want to make it very clear that within the bill with respect to information sharing, there is nothing in that Information Sharing Act that relates to spying, that relates to any type of national security agency making arrests or detention, etc. It has to do with the ability of one branch of government to be able to share information with another one. In fact, it only encourages that information sharing. It's not a mandate. It doesn't allow an agency to collect additional information other than the information that it may have already on hand. And it doesn't allow an accumulated database of information that can be widely accessed across all branches. So I just wanted to clarify that to begin with. Also, when there's been much talk and discussion about the specific clause that talks about for greater certainty, and the term that says it does not include lawful advocacy, protest, dissent, and artistic expression. Concerns around the use of the word lawful. It was very clear when in Tuesday's committee that this does not relate to even unlawful protests. For example, if someone doesn't have a proper permit to protest, because in relation to this specific clause, you have to take a look at the entire section in its entirety. And it begins to talk about the activities that relate to information sharing. It has to be related to activities undermining the sovereignty, security, or territorial integrity of Canada, or the lives or the security of the people of Canada. And I just wanted to clarify that particular section to you to help ease some of those concerns. I can't think of a single instance in my history of, I'm 49 years old, where First Nations has, brought something that would blow up infrastructure, that would kill innocent lives. Like, I can't think of anything in history that would connect First Nations to being a group that would be within the Information Sharing Act. Again, this is only information sharing. I just want to clarify that. It has nothing to do with law enforcement, has nothing to do with anything like that. It's just for the purpose of one agency coming across information that raises the red flag that there's an issue concerning national security, and it would be pertinent to push that information out. And also, I just wanted to, before I pass my time back to Mr. Falk, there was a comment made by Mr. Champ in his opening remarks about his concern why someone who was auditing taxes would be able to share information. I think that you might recognize that in the course of auditing someone's taxes, there may be a red flag raised with respect to money laundering related to terrorism financing. And that's why it's so important that if that information is found out, that in the course of the regular actions of that audit, they come across this information, that information is able to be passed along to our national security agencies. I would think that you surely do not believe that terrorist financing should be allowed here in Canada. But now I'd like to just pass my time over to Mr. Falk. I'm sorry if I've taken up most of your time. Thank you.
Falk.
Thank you, Ms. James. Last week we were able to watch the video of the terrorist that came here into this house on October 22nd with the Commissioner Polson, and we had the opportunity to ask him questions and listen to his presentation. Mr. Champ, I'd like to just direct a few questions towards you. Would you agree that Canada has experienced a terrorist act?
Canada has experienced a terrorist act?
Yes.
In the sense of someone trying to violently overthrow our government or commit a violent act to cause fear? Yes.
Okay. And do you think it is the responsibility of the government to ensure that its citizens are safe from terrorism as much as it is possible to do so?
Yes, of course. It's a laudable objective and a primary objective of government to ensure the security of Canadians.
Okay, good. In your testimony, and I appreciate your testimony, and I listened carefully to it, but I only heard everything that was broken or wrong with the bill, and I'd like to give you an opportunity to tell us what you think is good in the bill and can be built on.
Well, I think in particular the peace bond provisions. I was actually previously a Crown prosecutor a number of years ago, and I think the peace bond provisions, which would allow police to go to court and have conditions attached to individuals who they can demonstrate may well be considering engaging in terrorist acts. I think that's a good idea. The previous Section 810 of the Criminal Code, this bill enhances that and expands that a bit. I think that's a power that can really address almost every concern that I've heard thus far in terms of preventing someone from acting violently before they do so.
We are out of time now. We will go to Mr. Easter, please.
Thank you, Mr. Chair, and thank you for trying to find a way to have some fairness in terms of the rounds of questioning. And thank you to all the witnesses. Everybody adds something to this process in their own way. Time is a problem for sure. I do want to say in beginning on Ms. James' point when she talked about Tuesday's testimony by the minister. I submit that was the minister's opinion, not necessarily was it fact on the lawful, for greater certainty, lawful dissent. There's some questions around that. So I want to start with you, Chief Belgrade, first. I'm going to give you what I think in terms of your presentation. You can tell me whether I'm right or wrong. I guess I don't think you are opposing measures to protect national security of Canadians as such. You're concerned about the process of how we got here in terms of Section 35 not been followed. Am I correct in that?
Yeah, it's to a certain extent. Any law that's been developed by the Crown, which impacts on inherent rights, Aboriginal rights and title contained in Section 35, it's been proven there's consultation and accommodation has to be put in place, and First Nations have to be involved when any law is being proposed. There's notice has to be given, and that didn't happen in this instance.
That clears that up with me. Turning to Mr. Cooper, Mr. Cooper, you talked about after the fact review oversight as well as Mr. Atke before you. There's a number of proposals on oversight, whatever you may call it. There was a bill proposed in 2005. There was other proposals in 2009. Are you basically suggesting something along the lines of oversight that our Five Eye partners do, UK, Australia, United States? Is that what you're suggesting, or are you suggesting more a super circ proposal that would apply to all security agencies and not just CSIS? I'm trying to find out where you're at.
If it's a choice between the two, I'd go for super circ, and for the reason that if there's intelligence or information sharing among all these agencies, then there should be some kind of reporting after the fact.
So, but you're not isolating that to, there is no way current CERC can do its job with these additional powers. Are you suggesting that it apply, that it be done by parliamentarians be a part of that, as your brief claims, and should it be over all the security apparatuses, including policing?
Well, it's certainly over the RCMP, and yes, I would include members of Parliament under the same circumstances as the current CERC members operate. I mean, the Australians, as I said, have done this for a while, and it seems to be working fairly well, and they have the same kind of regime as we do.
The British as well have increased their oversight in 2013. Let me turn to Mr. Champ then. Section 6, and maybe you can explain this to me, and I'll just read what it says. For greater certainty, nothing in this Act prevents a head or their delegate, etc., from, under Section 5.1, from in accordance with the law, using that information or further disclosing it to any person for any purpose. What's that mean? I'm worried about that section. What's it mean from your perspective?
It's a wide open door. It's a wide open door to share information for just what it says, to any person for any reason. That's why we feel this bill is such a serious threat to privacy. It drops all the controls. That's really been the thrust of Canadian law for so long, right? The Privacy Act and everything. It's a pretty dramatic departure for Canada.
The first time that we've seen the word lawful dissent in a national security bill. It was initially in the one that we introduced in 2001. But the government of the day had the wisdom to amend that out. If the word lawful was amended out in that section of the bill, would it make it more satisfactory to you and the group that you represent?
I would say so, Mr. Easter. That's part of it. But again, I just don't think we've heard an explanation about why we're coming up with a new definition for security of Canada when the one in the CSIS Act has worked so well for so long.
Okay.
You'll have 30 seconds, sir.
Okay. Let me come back then to Mr. Cooper. Have you seen either Hugh Siegel's bill or the other one that's before Parliament that proposes oversight by parliamentarians?
Nope.
Basically, and I will agree with Mr. Atke that I do think the Siegel bill is better because it compels departments and agencies to provide information to parliamentarians who are sworn to secrecy on the day-to-day monitoring of those agencies. Do you think that's a reasonable approach?
Yeah, I do.
Okay, thank you, Mr. Chair.
And we have about a minute, Mr. Garrison.
Thanks very much, and thanks very much to all three witnesses for appearing today and giving very valuable testimony. Since I only have 1 minute, I'm just going to go to Mr. Champ and ask him, in view of this new terrorism offense that's being proposed, as a former prosecutor, do you think that this new offense has value in terms of combating the threats we face now, or is existing law adequate to do that?
That's the big point on that, is that existing offenses already exist for those who advocate violent acts or terrorism. And again, I'm not sure if it's really been fully explained why we need this expanded definition. You know, is it necessary and proportionate? What is the kind of speech that it's designed to address? Because everything that I've heard so far would already be captured by existing offenses in the criminal code.
And when it comes to information sharing, if I understood correctly, your concern is that it essentially tears down existing protections of privacy when the government deals with individual information. Is that the essence of your objection to that?
Yes, absolutely. Yeah. And it's not simply some of the individuals I mentioned. It's also a general problem. Knowledge that your information might be shared and collated, that's the language of the bill, into secret files creates a chilling effect for people who want to engage in you know, maybe unpopular speech or uncontroversial speech. But you know, that's what Canada's about. We're a democratic society. It's essential to a vibrant and robust society to allow that kind of speech.
Thank you very much.
Thank you very much, Mr. Garrison. And to our witnesses today, Mr. Cooper, certainly Mr. Champ, and certainly Chief Bellegarde, thank you very, very kindly for coming in here today. And of course, we will now adjourn till the meeting tonight.